Supreme Court has ordered a stay of proceedings at the High Court in the case against Zanetor Rawlings. The MP for Klotekoli, Niama Ashite, dragged Mrs. Rawlings to court, claiming she did not qualify to contest as the NDC parliamentary candidate for the constituency. Kwacha Afreniama was in court and joins me now in the studio with more on this story. Afre, for many who are watching this, what they want to know first of all is, how did the court arrive at this decision?
Well, let me give you a brief background before we get there. We know that when this particular matter was first filed at the High Court, the court had two opportunities. In fact, lawyers for Dr. Zanetor Rawlings had two opportunities in an attempt to get a court to throw out the case. The court refused to do that. It was after the last attempt, the second attempt, in fact, to get a court to throw out the case, that they took the matter to the Supreme Court, challenging the legal jurisdiction of the High Court hearing this particular matter. And this was a 5-member panel presided over by Justice Atugugba, and 4-1 dissenting, one person dissenting, so 4 in majority in favor of the position of Dr. Zanetor Rawlings' legal team, that the High Court did not or does not have the jurisdiction to hear this matter. And the reason the court gave was that, and in fact, when Dr. Zanetor Rawlings' lawyers brought this matter before the High Court, seeking to throw it out, one of the key decisions that the court arrived at the time, by interpreting Article 94, Clause 1, subsection A, was that Dr. Zanetor Rawlings, having not registered at the time, not being a registered voter at the time, did not qualify to contest as a parliamentary candidate of the NDC. And in the view of the Supreme Court, the judge erred by interpreting the Constitution, because on any matter that borders on interpretation of our laws, what the presiding judge should have done, the court should have done at the time, was to have referred it to the Supreme Court. So in their view, that should not have happened at all. Straight away, they should have stayed proceedings and said that the Supreme Court should take over. And so what the Apex Court has now decided, and this is a directive that they have given, that the proceedings at the High Court be halted. And they are going to interpret whether or not a Ghanaian citizen, by virtue of not being a registered voter, can be deemed to not be qualified to stand or contest as an MP, a parliamentary candidate, or otherwise. So this will essentially determine the fate of Dr. Zanetor Rawlings, whether or not the processes that the National Democratic Congress took by, vetting her and approving her, even though she was not a registered voter, was valid or otherwise.
Okay.
Francis.
Afra, interesting. And just before we look at the reactions of both parties to this ruling today, is this to mean that what was happening at the High Court with this matter will now be determined by the Supreme Court? It
will now be determined by the Supreme Court, because the substantive matter borders on whether or not Dr. Zanetor Rawlings can hold herself as a parliamentary candidate of the NDC, following from the processes that the party went through, again, based on the argument of the lawyers of Mr. Niama Ashite, that she did not go through the right processes, and they quote Article, again, 94, subsection, Clause 1, subsection A, and that is that's the major basis of their argument, and that is what the Supreme Court is going to deal with. Again, it borders on interpretation of the Constitution, and that is exactly what that's exactly what they do. It goes beyond the jurisdiction of the High Court.
Great, Afraid. So for the lady who took the matter to court, to the Supreme Court, Dr. Zanetor Rawlings, what was her demeanor today in court?
She was quiet throughout the proceedings, and in fact, even though she arrived at the court around 9 a.m., the court had a case around 11:30. And throughout the period, she was interacting with some of her supporters. She had 2 bodyguards in the court. Occasionally, they would stand up and watch around. And you have some... And the Supreme Court was filled today. On many occasions that I've covered cases at the Supreme Court, I've not seen this sort of crowd there. And so essentially, she was calm throughout. After the court delivered this verdict, it was clear that she was happy. This is not a finality to the substantive matter, but she was happy because they believe that this is a good first step for them.
I wonder what the lawyer for Dr. Zanetor Rawlings had to say on this matter.
Godwin Tamaklo says that they see this as a clear sign of what is yet to come, what the court's final decision will be, eventually passing their candidate through, saying that there was absolutely nothing wrong, especially in view of the fact that when the Electoral Commission opened the limited registration exercise, she's now a registered voter. They believe that there is nothing against her that prevents the medical practitioner from contesting on the ticket of the NDC.
Let's hear from Mr. Tamaklo now.
We are exceedingly pleased. This has always been our intention right from the first day. The judge had disagreed with us today. By the grace of the Almighty God, by 4-1 decision, the Supreme Court had agreed that so motu, they are taking the matter from the jurisdiction of the High Court, and that they are going to interpret Article 94(1)(a) of the 1992 Constitution. For us, it has always been our contention, and that is why the court today quashed the two rulings, first dated 22nd February 2016 and the 22nd day of March 2016. The two rulings today ceases to be law as far as the law books of our republic are concerned. And we are exceedingly pleased with that, the decision today. Yes.
And this does not mark an end to the matter. Election is approaching. You worried about the...
We are not. We are not. As you are aware, Dr. Zanetor Rawlings is free out there campaigning. What is important is that come the second day of June, when we appear before his lordship, we are simply going to just argue on the legal effect of Article 94(1)(a). And I want to find out from you, if you are an independent parliamentary candidate, at what time can somebody come to court to say that you don't deserve to be a member of parliament? At what time?
Some would say that at this rate and at this stage...
Would you want to construe a constitutional provision just to disable persons who go through political parties? That's where the matter is going. So we are exceedingly pleased today. In fact, the Supreme Court gave us more than we have asked, and we are pleased.
Some will say that at this rate and at this stage, perhaps the man who is challenging this matter in court, Mr. Nneoma Ashite, should simply back down. You say same?
What I would say is that it's still an internal family matter. I want to believe that what he's doing it in good faith. Let's see how it pans out.
Right then, so that's the lawyer for Dr. Zanetor Rawlings, Godwin Tamaklo, speaking to the press after today's proceedings. Kwacha Afreniam is still with me in the studio. Kwacha Afreniam, I'm sure that the MP in question who took Dr. Rawlings to court was there, wasn't it?
Yes, Mr. Nneoma Ashite was around, but he didn't speak to the press. His lawyer also didn't speak to the press. But I spoke to a member of the NDC's legal team, Mr. Kojoga Dawudu. He says he's not surprised by the court's ruling today.
I'm not surprised about the ruling. The court for some time now has not come up with a very certain position when it comes to, let's say, the Supreme Court, when it comes to when an interpretative issue arises or it does not. Let's begin in this way, that the Supreme Court itself, as Supreme Court, has three different functions. It acts as an original jurisdiction. When we say original jurisdiction, is that enforcement. When you think that there is any law which is inconsistent with the Constitution, you just go to the Supreme Court straight. You don't go to High Court or Court of Appeal. You go there straight. Two, when there's an issue also for interpretation, you think that the Constitution or there is a law which that there is a rival meaning on the two, and the court is invited by the parties to rule on that particular, and there's two different meanings. The words are imprecise or it is ambiguous, then the Supreme Court has that power, the sole prerogative to interpret that provision. And also it acts as the last resort when it comes to appeal. Now with this particular matter, because I said the Supreme Court has not been certain on this matter, that any case that goes there, it depends on the panel that sits and in what context that it is. So, yes, I think for me, I welcome this decision. And as the court itself has set down the issue to interpret Article 94, because the court has that power, so that they interpret it, because people are putting rival meaning on who is qualified as a member of parliament as a requirement. So I believe that if the Supreme Court pronounces on this matter, it will bring it to a logical conclusion, that it will make it certain who qualifies to be a member of parliament.
And under the circumstances, would it be fair to assert that Zanetor's fate still hangs in the balance?
I don't think so. It is until what the Supreme Court decides. Is it that whilst you're going, a party puts you as a candidate, and there is an opportunity to be registered, which the party also knows. You are registered before you get into, or your name is submitted, or even if your name is submitted and you are elected, is it until you get to parliament and sworn in as a member of parliament that you need to meet all this, or you need to meet all these criteria even before you take a slot? So this is what the rival meanings that the Supreme Court is going to talk about. Now, I believe there was also a dissenting view on this matter, because the same Supreme Court from 1971, in a case they call Republic versus Menkanka, it says that it is not every issue that is an interpretative issue that the lower court would have to refer to the Supreme Court. It says that before, it sets down 4 conditions before you say a matter should be referred. Because it says if every little matter comes and it involves constitution or any of the law, and the lower court, or let's say the high court, cannot apply that, then the Supreme Court will be inundated with frivolous cases that they should interpret every time. So if you go to the dissenting view, it also may hold that if the court was applying that provision, then the court could go ahead. And the 4 conditions that it should be ambiguous, imprecise. 2, the court should be invited. The 2 parties are putting different interpretation. Also, when there are 2 institutions and the functions are not too clear, so you'll be poaching on each other's territory, then you can, it's an interpretative issue that has to be referred. Even in 1980, a case called Ex parte Acosa, the special tribunals that were set up, the Supreme Court also said the same thing, that it's not every time any issue arises that has to become. So Supreme Court has also spoke lengthy. There are several litany of cases that the lower court will not have jurisdiction to interpret that, but it's the sole preserve of the court. Then there is the enforcement, how it could be enforced, any provision to be enforced. That is, if any institution or any organ of government, is going against the Constitution, the Supreme Court is bound to enforce that provision. So that's why you could see, let's say, Abu Ramadan's case, they are saying that Electoral Commission and others are violating the rights of the people or others, and they went to the court straight. So that is an enforcement, which the ruling is another thing maybe we may discuss in a different forum. So this shows it's what the...
And tell me, you're a member of the party's legal team. Is the NDC worried about this back and forth? Of course, Klote-Kole constituency is one of the key areas that you are, it's a swing seat. The party is seeking to retain the seat. You're worried about how this matter is going a few months to election. This case is still in court.
You are soliciting my view as a legal practitioner, a member of the party. Now, I'll give you a position that, yes, I'm a member of the party, which the party believes that it's the law that is being tested. The party also believes it has okayed a Zanetor to run. If there are issues, we should allow the course of justice to run, so that definitely I believe the party will have an alternative, because the party was initially joined to this action. Yes, and the party will not want to take sides, whether the plaintiff or the defendant. It's a family issue. They are doing it, and I believe that they want this position to be settled once and for all. And I'm not speaking as the position of the party. I believe that the General Secretary will communicate the party position. But I believe this is what the party is doing, that the matter, let it be resolved.
So that's a member of the NDC legal team, Victor Kojagada, explaining what the ramifications are for this ruling today. Kwacha Frenyama is still with me in the studio. Afre, yesterday the ruling has been done. It means that the substantive matter will be dealt with by the Supreme Court. When is that happening, and what will happen on that day?
The lawyers on both sides have 2 weeks to present their submissions to the court, and the next sitting has been adjourned to June 2.
June 2. So we should mark that date in our diary and expect a ruling on that matter that day.
Not necessarily a ruling. The court will start hearing on that particular matter, but the Supreme Court has stated that because this is an election-related matter, it would want to deal with it expeditiously, especially because a few months to the poll itself, the candidates, whoever it is, needs time to campaign and all that.
Okay, thank you. Thank you so much, Kwacha Frenyama, for those details from the Supreme Court today on this matter involving Dr. Zanetor Rawlings and Nneɛma Akyete. We know that this issue has played out in the High Court for a while. Dr. Zanetor Rawlings took it to the Supreme Court, questioning why the High Court should have even the locus to discuss this matter. Today, the court has indicated, the Supreme Court has indicated that indeed they have the powers to interpret the Constitution, and so all proceedings at the High Court have been halted. The Supreme Court takes over the matter for now. The trial will start on the 2nd of June. At this point, we'll go for a break. When we come back, there's a very interesting discussion